Still afternoon anyway. All right, good afternoon, everyone. Welcome to the August 12th meeting of the Arlington County Trespass Towing and Advisory Board. And I'm Dave Kennedy. I'm the chair and the citizen representative for the TTAB. To my right is Al Leach, who represents the towing companies. And to my left is Detective Jim Toomey, who represents the Arlington County Police. So I'm going to call this meeting to order. And we're going to start with a review and approval of the minutes from our last meeting. And I think you all have picked these up outside, so you all should have a copy of it. Just going to highlight, because this came up in a prior discussion. Al did make a motion last meeting to increase the Arlington County tow fee from $135 to $150. And that Jim seconded that motion, and through unanimous support, the motion passed. So just this was a clarification, and I might need Arlington County staff to just give me a thumbs up. That will then be presented to the county board at a future county board meeting for them to approve. Yes, the thumbs up.
Yes.
Okay. Any other comments on the meeting, on the minutes from the last meeting? If not, I'll ask for a motion to approve from one of my seconded. So we've approved the minutes from the prior meeting, which was, I believe, actually, just so we have it, if it was June. I think it was June 22nd, but I want to confirm that. It was a June meeting, I know that much. And then moving on the agenda, before we continue on the agenda, or tonight's agenda, last meeting was really important. I just want to make sure we're all on the same page, because we talked about three things specifically at the last meeting in June. And what we did, the three things that we did, oh, I'm sorry, it was July 15th? Was that the meeting? Was that the meeting that was postponed? June 4th. Okay. The last we met was June 4th. And we did three things that were important at that June 4th meeting. Two things came through the code, the state code, and the TTAB approved these two things to be included in the ordinance, the proposed ordinance for the TTAB, or for the that'll ultimately go to the board. We adopted the 48-hour rule, which said basically multi-family dwelling units required a sticker before a legal tow could be made. And that would be a 48-hour grace period. That's part of the proposed ordinance, and that was approved. The second thing that was approved was to allow a $20 fuel surcharge, which will expire July 1st of 2025. Also, again, coming from the state code that was approved in Richmond. So those things, the TTAB unanimously approved. And then, as we talked about a couple minutes ago, we also approved the tow fee, which hasn't been increased for my understanding 11 years, from $135 to $150. And again, all these items will still have to go before the county board before they are official as far as the county's concerned. The next thing I want to do is just take a quick glance at tonight's agenda. We've covered the first two items. The next item is to approve tonight's agenda, which we'll spend a lot of time talking about the permitting and the appeal sections of the proposed ordinance. Then we'll move on to item number 5, which is new business, discussion of another proposed ordinance change related to storage facilities. We'll then move on to discussion of next steps, and then public comment, where you all can come to the podium and speak to specific items that we'll be talking about tonight. That'll be the public comment period. And then as applicable, if there are, what we want to try to do tonight is get through the full proposed ordinance and have the TTAB vote on recommending to pass proposed changes to the county board. And if we're in a position to do that, that'll be the last agenda item for tonight. So I need from one of my colleagues here a motion to approve the agenda for tonight. Second. Okay. The agenda is approved. And now we're going to move on to our discussion that we started last at the June 4th meeting, which will now continue tonight. And that's specific to, and I'll just give the official citation here. So this would be specific to the Arlington County Code, Chapter 14-3, titled Immobilization, Removal, Towing, and Storage of Vehicles from Private Property. And we're going to specifically talk about section 14.3-12, permits, and 14.3-13, the appeal process. And so my understanding is, since we're not at public comment period yet, the discussion is for the three of us, Jim and Al, to just, and just so you all should have that, right? You have that, okay. So I think I'll just give some introductory comments. This is this would be a new section to the county ordinance, and it has been significantly modeled on what is on the books in Fairfax County. Jim or Al, do you have any initial thoughts or discussion that?
You're 14.3-2, correct?
14.3-12 permits. This would be on page. It's in red. This section here.
Definition.
Permits. Yeah, we can take a second here. Okay. I mean, it's up to us to kind of discuss and raise anything we want to share as far as discussion. Again, this all would be brand new to the county code. My understanding from the last meeting And again, I hope this, I think this might come up during public comment, is that for section B, the 8 requirements required to obtain a permit to tow vehicles from the from a private property, the following documents must be provided. And these 2 of them actually are, well, I guess 3 of them have always been required, but 4 through 8 would represent brand new language. And again, my understanding that was a section that some folks wanted to speak about, and during public comments, if you guys want to come up to the mic, you'll be able to do that.
The only problem that we had before.
There we go. Yeah.
Testing.
Yeah.
The only problem we had before is in Fairfax, they call it registration. Here they call it permits. And I believe it's the same language. I just want to I want to make sure that the permits cannot be taken away. I don't see that anywhere in this.
Well, if you
draft.
If you move on to section G, suspension.
Okay.
That would be the section that would speak to having a permit suspended.
Oh, sorry.
Yeah.
I can help a little bit with this,
Okay.
maybe. I'll try. So yes, Fairfax has registration. They also have permits. They're very similar in how they're structured. And you will find our draft code is very closely mirrors their enacted code. I do want to point out a couple key differences. And it would be in section 14.3-12, letter B, and it is number 8 is different from Fairfax. And then as well as one second, let me find it. I'll get back to you on that one. 1 second.
Yeah, I got the
I think they have it now.
And the other one that is different is number 7 in letter B, where it refers to copies of the driver's licenses.
I agree with that.
Okay. So 14.3.12, and just we have sections A, B, C, D, E, F, G, H, I, J. And again, the basis is Fairfax County, and Caitlin pointed out a couple of the differences between Arlington, what we've drafted for Arlington compared to Fairfax County. Give me a good with any comments on any of those sections?
Yeah, I'm fine with it. I mean, the suspensions, application denial section, and the revocation part are all pretty similar to what Fairfax has for tools to be able to enforce consumer protections. And that, so I think that there's nothing in there that's overly over the top. So I don't think there's any issues from our part.
Okay. All right, well, let's move on to section 14.3-13 appeal. And again, this is pretty much modeled on Fairfax County, my understanding.
Yeah, I think the appeals process is pretty much like our standard appeal for any kind of denial or appeal or suspension for such as for like the taxi staff and vendors. So it's pretty much the same process that would go through.
Okay. Al, I know you're eyeballing it right now. So what we're going to try to do in the next few minutes, and again, there will be an opportunity for public comment, but what we want to do is just make sure that the three of us are comfortable with this language. And then from there, we can continue as needed, any discussion around this after the public has had a chance to comment.
Can we just go down maybe line by line real quick? Would that be
On the
quicker
appeal
than-
process?
Yeah, and then maybe that everybody will understand. Or maybe I'll understand better.
Okay. You want me to talk through it?
Yeah.
Okay. So, I've tried to take some notes on this. So basically it's all about if there is an issue with the operator's permit. And if the permit's been revoked or denied or suspended, these are the rights of the operators in order to address what may have happened to them.
That would be the owner of the towing company?
That would be you all, or that'd be the towing companies if they're, and it's really driven by if something happens in the previous section. So 14.3.12, a permit was denied, or a permit was suspended, or a permit was revoked. These are the remedies you have as a operator to appeal that particular.
And who has the power to revoke your business license? Would that be the county manager or the police department or?
Well, actually, let's go back to G on the previous page. Suspension. The county manager or his designee may suspend an operator's locality permit for a period of 1 to 60 days. So it is the county manager or the designee. Same goes in the previous section F, application denial. The county manager or his designee may in their sole discretion deny an operator's locality permit. And actually now going to H, revocation, an operator's locality permit may be revoked by the county manager or his designee. So it's really going to be the county manager or someone that the county manager designates.
I mean, I have to be honest with you, this leaves it wide open. And, you know, we have a really big investment in this. And if the county manager, we tow his maid's car or, you know, the county manager's girlfriend's car, and they just decide, I mean, don't you think there should be, that's why we have circuit courts and we have the court system to say it was a wrongful tow and to make it right. But just for somebody to come in and suspend your license when you have 20 or 30 employees and a lot of expenses and truck payments, I just think that's absurd. And Fairfax County does not do that. I can promise you. I think that's just an overreach myself.
I don't,
If we did what if we did what Fairfax County we've been trying to do, where we have a process that we answer complaints and the towers talk, and we talk to the police and the county managers and we fix any issues, that's not going to put anybody out of business, and that's not going to stop our drivers from paying their mortgages and their groceries and their house bills and their health care and Medicare and all that. I think that's really, really overstepping the boundaries of the county. If there's got to be some way, if the towers don't answer the questions, don't make it right, or don't, there's got to be some kind of appeal process before they just pull our permit.
well, that's what the 14.3-13 is. That's the appeal process for if the county manager or their designee decides to go down the route. And I don't think the county, with this suspension of the revocation, is going to use it in such a way that it's going to be a punitive punishment for a one-time, one-off kind of event. I think this is for a company that decides to blatantly disregard the county ordinance, the state law, and who's been doing multiple violations. This would be the remedy to rectify that situation. With the application denial, I mean, if you don't have the approved storage site, the business license or the properly licensed to the state to conduct your business, I mean, everybody here can agree that we don't want those type of companies operating here in the county. So I think the application denial part is perfectly, well within the boundaries of what the county can do. But for the suspension and revocation part, it's not going to be used as a tool to, if you tow the county manager's maid's car. I think that's going to be more for those companies that are going out there and who are ruining the reputation of tow industry, of you guys, of the tower industry, people who are trying to do a professional job and to make commerce move here in the county. But if by chance the suspension does come, that's when 14.3-13 happens. So there is a remedy for a suspension so that you can argue whether or not the suspension was done, was warranted, was not warranted, was done lawfully. There is an appeal process.
Yeah, I see that, but who hears the appeal?
I believe it's in here. It's
We can go through it. So first.
Can I interject one thing? I just wanted to point out that the conditions for denial and revocation for Fairfax are the exact same that we chose, and they are currently enacted. The director of the Department of Cable and Consumer Services, she is able right now to revoke permits from towers in Fairfax County based on these exact requirements, these exact conditions.
Suspension also would.
Yes, suspension.
So denial, suspension, revocation.
Like that's, yes, she has the power right now to do that. A permit, not a registration, but a permit.
And those are designed not to be arbitrary. The very specific citations, I guess, would be the driver for one of those actions taking place.
Well, I know Fairfax County, they can do it in your registration if your lot's not well lit, if your lot's not insured. I don't think I've been on that board for a long time. I have anything where they can suspend the company. I'd have to look back at that, but I think this is just not. It just doesn't really. It doesn't say who's going to authorize it. Is it going to be done by a judge, a county manager? If one of our drivers has a bad day and makes a mistake, is the owner going to be out of business because we all have employees. They're all not 100% all the time.
I can add to when it comes to the appeals, it says county manager or his designee, but that's still up in the air. TTAB will have an input on that, on determining who will hear the appeals. So that's still on the table.
I think the point you're making, Al, is a good one. It can't be arbitrary. It can't be we don't like this person or that person, so we're going to put a microscope on him or her or their business. I mean, I think take suspension, for example. The county manager or the designee can show up and cite you and revoke or suspend your permit for 1 to 60 days. Specifically, if you fail on one of these 8 things, you operate a tow vehicle that is a piece of junk, let's just say. I mean, it's just not up to standards. They could also do it, any violations of this section. So if you don't submit your contracts, if that previous section that said the things you have to have on file with the county, if you are not providing the proper paperwork, you can be suspended for 1 to 60 days. You can also be suspended. The way I read number 3 is if you've been denied an application and you didn't get a permit, but all of a sudden you're still operating your business. Well, that makes sense.
I understand that part. That would be common sense, yeah.
Failure to maintain the storage site in good repair. That might be related to what you said in Fairfax. You don't have proper lighting.
Sure.
Number 5, failure to pay fees and taxes. Number 6, failure to not have maintained proper insurance. Number 7, valid consumer complaints regarding trespass towing. That would be one that, if I was the only one who complained about a bad tow and you were suspended for that, that to me would be arbitrary. But if you're getting 3 or 4 complaints a week, then that probably would not be arbitrary. And then number 8, failure to comply with duly executed complaint investigation. So I guess that means if the county manager or his or her designee comes to your site to follow up on some complaints and you don't cooperate, that would be a reason for suspension. So I think they're designed to be very specific. And again, I'm fast forwarding to the public comment period and what's going to happen over the next 2 months. If there's anything in this language that you think is unfair or is arbitrary, I think it's going to be really important for the towing companies to respond to the public announcement. There'll be a public announcement that invites you to an invitation to respond. And that's where you want to be really specific and say, you know what, number 7, the way that's worded, I think that's too arbitrary. And I think it's going to be up to you all to make some really strong arguments during this invitation to respond as to why it might not be. This isn't the last chance, put it that way. That invitation to respond is really important. Anything that within this language that is just you feel is unfair or arbitrary, you should absolutely be strong in your response. And then so that's what's going to, any breaking of the rules, let's call it that, in section 12 is what's going to lead to a suspension or revocation of the permit. And then the appeal process, that's where you need same thing. Do I now have a fair appeal process that I can follow to address, I was suspended for 3 days. I want to appeal that. What's that appeal process look like? So you want to take a look at that section and just see if we're feeling good about that. Letter A, any party that's, let's just say, been suspended may appeal, and you have 30 days after receipt of notice to appeal. Letter B, your appeal must be in writing and filed with the proper, I guess actually the staff coordinator. Oh yeah, so yep. So the right people that's who you're going to file your appeal with. Each appeal is impartially reviewed for completeness. Letter D, upon filing an appeal, the staff coordinator shall notify the county board. So this brings the county board, notifies the county board that your business has been suspended. An appeal may be, in the letter E, an appeal may be withdrawn at any time prior to a hearing. So it's possible that you can resolve this before an actual hearing. Letter F, an appeal may also be withdrawn administratively by the county manager or his designee if there was an error. Letter G, the appellant shall have the right to present their case in the county board meeting. Letter H, the county board shall consider the case. Letter I, a letter of determination will be issued to that person appealing. The decision of the county board or its designee is final and may only be appealed as permitted under applicable law. So I guess at that point, that could be the case where you need to use the court system.
Also under I think this is important for the towers. If you're suspended, it's not going to be like an immediate suspension. If you appeal it, which, this is what this is going over, it's going to be effective after your appeal has been exhausted. It's not going to go into immediate effect. So like if you get a letter from the county saying, hey, you're currently suspended, it's not immediate effect. It's going to be after you've appealed, after exhausted your appeal or decided not to appeal, then it will go into effect. So it's not going to be, if you get suspended by the county, it's not going to be an immediate hit to, I think what you guys are worried about is it's going to affect your money. It's not going to affect that until you've exhausted your appeals. And if you lose, if you win, then you don't get suspended. I think that's important under I. It's the last sentence there.
Yep.
It says the suspension shall be effective from the date of the county board's or its designee's letter of determination. So I think that's important.
So just actually, that is real important. So what happens, just to be clear, you've gone through this process, you've been notified you're going to be suspended or your license is going to be revoked. It's not official. When does it become the county board?
It becomes official under this section. It becomes official after you've exhausted your appeal. And if you're no longer allowed to go to the court system for a court appeal of the decision, it'll become effective at the time of the designees or the county board's letter of determination.
Yep. Okay, letter J, if the county board or its designee reverses the decision of the county manager. So it's still at the county manager. The county manager still seems to have the authority, but then it can go to the county board, and the county board could reverse the county manager, which would then restore the permit. How about letter K? Except as otherwise provided, an appeal of the decision of the county manager to suspend shall stay the effective date of the suspension. So that's what you were saying. Yeah. And again, the one thing that doesn't, if the suspension or revocation is based on failure to follow safety procedures or falsifying documents, then the decision of the county manager shall remain in effect until the county board has rendered its appeal. So if, again, let's come back to consumer complaints. If there's 4 consumer complaints every week and, there's a decision, the county manager says we're going to revoke or suspend, that's you're going to be able to go through the full appeal process. But if you're not maintaining your trucks and your facility doesn't have proper lighting, you're not following code in certain things, that actually looks like it's a more egregious situation. Letter L, the provisions of this section are not exclusive and do not relieve the parties of the contract subject. In the event of a conflict, in this letter M, of an action of the state and county, the county ordinance shall be controlling. That looks like it's just administrative language. So that's, I mean, I think there's still, some deep diving just to make sure it's understood, but that there is clearly an appeal. There is an appeal process that I think has been thought out. And again, just to confirm, Caitlin, this is pretty consistent with Fairfax County, the appeal process?
Yes, except for ours is 30 days and Fairfax is 45 days. But everything else is pretty consistent.
Okay.
Section A.
Okay. Okay, so that's once, you have to appeal within 30 days? Okay.
I think this section gives the towers enough safeguards so that if for some reason you do have a rogue county official who wants to go out there and take advantage of this code section, I think this gives enough safeguards to make sure that can't happen. So
I just see there's some open issues, the county board member or his designee or their designee. I don't know if that's going to be us, the county board members, the towing inspector. Are they going to give you time to fix the issues? I've never had a problem in Fairfax County in, I think, 12, 13 years. This was never brought up. The registration was just that we saw was for the towing, the lights, the 24 hours, the release on the credit cards. We've always settled any issues through the complaint process. I would feel better if there could be some wording in there that they just don't come in and say, look, you got to close down your business. I would like to know who's going to make that decision, why, and there has to be a process that, to fix the issue or to at least to prove that your innocence or your guilt or however it may be. I'm not an attorney, but it just looks like a lot of ways to close somebody's business down.
On the flip side of that, Al, I think that, like you said, Fairfax hasn't had to do anything with this. It's on the books, the suspensions, revocations, and Fairfax hasn't used it, which I think is a testament to this code. Right. I think it's used as a tool to make sure that rogue towing agencies, predatory towing companies, can't operate in Fairfax County. And that's why they haven't had the opportunity. That's why they haven't had the need to use this. It's because everybody's following the rules that are set forth. I think that's what this is attempting to try to do here is to make sure that everybody's playing on the same sheet of music, we're playing on the same court, and that there are safeguards just in case something should happen for the consumer, that the county can then immediately rectify that company, that situation, and then just in case the county does error, because no one's perfect, and Lord knows Arlington County is not. However, it's very close, very close. There is a appeal process to handle that type of situation, so that it can be addressed and identified and made whole if we need to do so. So I do believe that since this is modeled very closely under Fairfax County's ordinance, and it's a testament to Fairfax County's ordinance that they've never had to use or suspend or revocate someone's license or permit or registration. I think this goes to show that this is going to be not a burdensome part of the ordinance. I think this is going to just go ahead and be like just that thing that puts everybody on the same court and helps the industry gain not gain trust, but help the industry operate here under better terms.
And I do agree, and that's the complaint process in the county has been great. I mean, there was some towers there that weren't doing their job, and they weren't answering the phones. They were holding people's cars hostage, and that 4 or 5 of them, and they, the county made sure that they weren't able to do business. But some of these people, you know how much the real estate is in Arlington County, and as long as there's an appeal process, that you have a time frame that you just came in and say, oh, you towed 2 cars last night, you're out of business, you're shut down for 7 to 30 days. I would just like to know who the designee might be, and and of course I know who the county manager is, but that's what I would like, just to make sure that no towers just put out of business because of just one bad apple. 30-day appeal process, 45-day appeal process, to get your ducks in a line or to prove your innocence. I think that's fair to any private business.
Just to confirm, my understanding under capital letter A, under appeal, the aggrieved party, any party aggrieved, may appeal the decision of the county manager or his designee within 30 days after receipt. So you're not going to be shut down that night. You're going to have 30 days to make your case. So that's a really important protection, that you're just not, again, I think the one thing, if you're running again, your trucks aren't in compliance with state code and there's all sorts of safety issues. I don't know if that 30 days would that still be true even in that situation?
That would be the police department, the record, or reckless driving or faulty equipment. That wouldn't be the staff coordinator, I would believe. I'm not an attorney. I'd like for our attorney to look at it, but I mean, as long as there's an appeal process, there's just so much wording in here. I just would rather have somebody look at it before I make the decision. I don't really have a big fight in the game, but I just wouldn't want this to come to Fairfax County like this. And I have never, maybe because it hasn't been brought to our attention, but I've never read like this. And I would just like to let my attorney look at it and see what he thinks.
Absolutely. Well, and I think that's why this process is real important. I mean, whatever happens next, I still come back to the invitation to respond, which that would be, there might be 3 sections of here. Maybe you think the 30 days should be 45 days. And your response is 30 days is not enough time to get our ducks in a row, because there's a lot of paperwork you're asking for, and we think this should be 45 days before we're actually suspended. I mean, that could be the type of response you could work with your people, your legal team, to say, hey, this one needs fixed. And maybe I'm just being arbitrary, letter K, there might be something under letter K that says, hey, this would be better if there was a little more specific language. Maybe the designee. What is a designee? If you're worried that the designee is going to be this random person that has a grudge against the towing companies. I mean, anything, again, that if we approve this tonight to go to the county board is required to put an invitation for you to respond to specifics. And if any of this language is of concern to the towing community, then that's taken seriously. I mean, that's really an important part of the process.
I think if we could, David, I just want to jump ahead to one of our agenda items to discuss the Fairfax County Code, because I think this is going to help out. We are all supplied with the Fairfax County Code. Under the Fairfax County Code, as Al was saying that he doesn't recall seeing it, it's actually here in the county code for Fairfax. They have an appeal procedure. They also have a procedure for suspension and revocation underneath their code, which almost mirrors what we have here. It's going to be on pages 13 of Fairfax County's code, pages 13 of 16, and pages 14 to 16
I'm with Al on this one. There's a lot of reading here to do a short amount of. So this is, okay, this is so we do have the Fairfax, and all of you came in, you also got the Fairfax County Code also.
I believe it was also attached online.
Okay.
But yeah, so to handle this particular situation, the Fairfax County Code does have a suspension, revocation, and appeals process that is, and a denial for the permit for the ability, which is very much I would probably say like 97% to 99% what Arlington County has proposed here, what the staff has proposed here today.
So that, just to confirm, that's on page 13 of 16.
Yep.
Suspension, letter B, letter C.
And then I think it's also the denial part's on 12. So I think it goes from 12 to page 12 to page 14 of the Fairfax County Code. Discusses the locality permit operators for the denial, for the suspension, for the revocation, and then it goes into the appeals. And like Ms. Thomas said, the only difference for the appeal is Fairfax County is 45 days, and I think Arlington has proposed a 30-day appeals to be filed within 30 days.
So that appeal of 60 days is on page 14.
Yep.
I. There's 60 days, 60 calendar
Yes.
days. Okay.
Oh, no, the 45 days is right.
Oh, 45. Oh, okay. So letter I2, Roman I.
I just wanted to add one thing, that the draft language that the county has proposed that we are reviewing tonight is the same that was at the previous meeting. There have been no changes.
So that actually could be a good exercise. I mean, again, I know it's a lot to read, and we're not going to digest it all, but to really do that comparison, and you can see there is,
Different.
I mean, there's definitely differences, but I think, again, that's to your point that, anything that's, I mean, that I'm not saying the Fairfax, I mean, you may have issues with the Fairfax County Code, but that's a whole different process to adjust that. But using that as a model to compare against Arlington, the proposed Arlington seems like it'd be a good exercise.
But just like I stated before, I think the fact that Fairfax hasn't, even though it does have it in its code, and the fact that they haven't had to use it, or that you didn't even know it was in there, is a testament to that the power that the county is trying to give to both the towers and to the consumer, so that they can do their job, and everybody knows they're doing their job by the code. And the consumer is having protections from those predatory companies that come in, fly by night, do some damage, ruin the reputation of tow companies, and then just disappear and leave the county. This gives the county the ability to address those issues. And like I said, this is never going to be a punitive punishment. It's going to be, going after those companies that are routinely causing violations, problems, predatory companies. And I hope that we never have to use anything that's in, 14.3-12, that everybody gets on the same page. We're all operating perfectly, and we never have to dive into these punishment sections. But it's also, I believe, a very important consumer protection for the public, for the people who are coming here to work, spend money, that they have the ability to trust the system is protecting them from predatory companies.
Well, I agree, that the bad towers that, they've been taken out in Arlington County, they do a lot of towing, and there's only really 2 or 3 that do most of it. But a few things that bother me is just designate, the director can suspend in Fairfax, which I'm assuming that's Carl, but that changes. And, they have the county manager here, and the county manager, you know, County Motors gets voted into office, and of course, the people that get their cars towed aren't going to be happy, so they're going to contact the county manager. I just think that I don't know how to make it fair. I think the board should decide on if somebody's suspended, and the board should decide on complaints, just kind of like Fairfax County does. And the towers, the consumers make the complaints, the board looks at it, they contact us, we write our letter and what we have and show our evidence of photos, and then the director makes his decision. So I think either a judge or the board should vote on it. I don't think one person, being the county, the president of the board, should make the decision.
Can we?
I can clarify. So the manager's office issues the revocation or denial, and the county board, which is elected, will hear it. Will hear the appeal. Right. The county manager is appointed by the board.
Is it true then? Does the back to the Fairfax County? Do they have the same title, county manager and designee? What do they use?
So they have a Department of Cable and Consumer Services, which has unique powers that we do not have. And so Carl is in that department. That's who Al's referring to, their towing counterpart, to me, I guess. But the director of that department is the one that issues the appeals, and they have a Consumer Protection Commission, which hears the appeals. So they have a board of supervisors, which is comparable to our county board, but that is not who hears the appeals. It is their Consumer Services Commission.
Do we have a vision in Arlington County of, my guess, the county manager is obviously integral in all this, listed numerous times. Designee, though, would probably be the one doing a lot of the work around this. Do we have a vision of what a designee would look like? Would that be someone out of the, I mean, because I think I think what Al's, if I'm hearing it, is just not that kind of amorphous person, whereas in Fairfax County, you say that the consumer complaint division becomes kind of the point here, and you can point to people, maybe people you know. Do we have a vision of what a designee could be? Or,
well, I do want to first say that a lot of our code is written as such, county manager or his or her designee. That's pretty standard across a lot of our code. So I don't want this to be thinking that this is unique to that. So that's for one thing. But I can't speak to the vision. I can't speak to what is in place. The manager will make the decision on who or which department enforces the permitting system. I mean, there's some logical places, but I can't speak to the decision that has been made or will be made. Mm-hmm. And TTAB is, of course, more than welcome to weigh in, and that feedback is welcomed.
But it's definitely out of the county manager's office, for sure. I mean, that's the designee could it be within the, can it go, I mean, is there another, I mean, the police department, could the police could be the designee?
Right, their staff. Okay. So the county manager could designate the police to administer the system.
Mm-hmm. Okay.
To put it in perspective, inside the current towing code, it's the county manager or designee who will investigate all towing complaints. That designee turns out to be the police department for Arlington County. So it's very common language that that the county uses throughout the code, just to kind of, so they don't have to buttonhole any one particular code section into any one agency, just in case they need to move it and be a little bit more fluid with it.
Mhm.
It allows it to move to where it needs to, where we better fit at that particular point in time.
Could language such as the designee, the county manager or police department or appropriate designee, something like that, or
You
would
can do
that?
whatever you want.
I'm just trying to get it, Al, is that, just try, I mean, is that the concern that the designee, it just becomes too amorphous as to who would be investigating, who would be the,
I think the designee word in when it comes into our code is that generic word that, like I said, it's the person that's going to be best fit, or the agency that's going to be best fit to handle all of this. And the county manager's office, and I think the county board to some extent will make that recommendation to determine where is this best to land.
Mhm.
And of course, the TTAB, I mean, I would hope that the county board, county manager's office would ask for our input as to where it could land.
Yeah.
There's nothing that says that it can't even land here for,
Mhm.
For just the sake, saying the TTAB can, do the appeal. There's nothing in there that's going to prohibit anybody from doing it. I think it's going to be up to the county board, county manager to see where it's going to land and see where it fits best.
So the citizen rep can be the designee? I'm just kidding.
Can we, there's, we stay down in Richmond so much or something. Can we open that up for public discussion for a couple of the other time?
Well, we did-
We're
We're going to
have to be later on at a certain time.
yeah, let's stick to the agenda of
Before we-
public.
Okay.
This has been a good conversation. Why don't we move on? Because we still have one more piece of new business. Well, let's move on to the new business, which is specific to storage facilities. And I think that, Caitlin, that might be it. Is that 14.3? Should that be -7?
-7, yes, that was my mistake.
Okay.
14.3-7, letter A.
Okay. So this is something, storage facilities to which vehicles towed under the provisions of this chapter are towed shall be located within the county or at a location in the Commonwealth of Virginia that is within 3 1/4 miles of the boundary line of the county. And I believe, Jim, you have some context on this, the storage facilities, or are we just, I don't know. I don't have is this new language? I just want to.
This is not new language.
Okay.
There is not proposed language on this. It was brought to my attention from the police department regarding the location from which tows are originated to the storage location and the distances. So I don't want to, I'm just facilitating. So I would invite Jim to comment on that, or maybe ask Tanya if she wanted to elaborate.
But the goal is to make it so that the storage facility is close enough to the county that it's not a burden on the person who was towed to try to get out to that storage facility. That's what this is addressing, that type of issue, so that from the it also puts in a more defined 3.25, because the state code is similar to, it just defines it for our code.
But this is not new. I mean, this is currently part of the code.
Yeah, last 8 years, I believe. It's been in the code.
Okay. So we like it.
Yeah, I can clarify. So right, that there's not draft language in front of you to change. The concern it's on the agenda is that there have been some tows documented that were in excess of the 3.25 miles in total distance. And so the proposition is to change the 3.25 mile distance from the boundary line to the tow lot to the they would like discussion on changing it to the origination of the tow to the tow lot to make that total 3.25 miles.
Okay.
Can I comment on?
Yes, please do.
We spent a lot of time with Google Maps when this came out, and Arlington's a pretty small county, and I think it was Lieutenant Goff back then. We rode around, and Henry's towed for Arlington County Police, Al's towed for Arlington County Police, A1. All the towing companies are within the 3.25 miles. All of them, every single one of them that towed out of Arlington County was within the 3.25. That's why we didn't go to 3.5 or 4. Fairfax allows you to tow 10 miles out of the whatever from the from where your car is. We have I can tow to Loudoun County where my other lot is from Fairfax County. 3.25 miles is for all the towers that are in here, for all the towers that tow in the area, for all the legitimate towers that are in this area. They might have had some issues in the past, but I can't see that's very many. You might know more than I do. We're right off 66. The others are right off 395. So we're all close to the metros. Lieutenant Goff looked at that. We're a Dunn-Loring Metro. They're a Dunn-Loring Metro. That's where this originated from, the 3.25 miles. And as you know, soon there's not going to be any more land that you can store cars in Arlington County for my lifetime, I wouldn't believe, unless they're going to have hovercrafts. But so I think that's probably the best we can deal with.
And we're not looking to change that that 3.25 has been on the books like he's for 8 years,
maybe longer, but no, at least 8.
Okay.
Yeah, I think the 3.25 is the same. What's the difference in this proposed than what's in section F of ours is this is going to, the 3.25 starts from where the tow, where the tow was. In our county ordinance, it currently says from the boundary line of the county. So what it's going to do is it's going to help the consumer to kind of shorten up that drive, so that if you tow from, a far out region of the county, you can only go 3.25 miles from that far out where you towed in that far out region to your lot can only be 3.25. So not from the county boundary.
So we want to propose new language that says that is within 3 1/4 miles of the origination of the tow.
I believe that's what that,
I
believe that's what that is. Yeah, tow shall be located.
Is that a problem? How many issues are we having from the towing coordinator? Is that an issue? Because does anybody know? Because I can't hire a mathematical engineer to watch Google when we tow a car.
Yeah, I don't have that.
I know we're 3.25 miles out of Arlington County. If it's not an issue, I don't know why we're discussing it, to be honest with you, but.
Yeah, I don't quite have the context either, but I guess if you're within 3.25, so I guess if the tow is in Roslyn and you're 3.25 miles outside the county, then all of a sudden we're talking 6 miles, right? So that's the situation I think we're trying to address here.
Well, it would be perfect for Mr. O'Neill, because if we did that, he'd have every tow here. He would have every tow because, yeah. So, if you got it, on the other side, I just think Fairfax, not to keep saying Fairfax, but I think most of the jurisdictions, Alexandria, that, there's not a lot of real estate in Arlington County anymore to buy. I couldn't buy it if I couldn't buy 5 feet of it. So I think the 3.25 is fair for the consumers. Like I said, we're all within the metro. We're with all in a $12 Uber ride. I just,
I think I'm going to suggest, since we've been talking about the permitting and the appeal process for over 2 months now. And I think we really had a great discussion tonight, and we're going to open to public comment in a few minutes. I think this item would be worthwhile to just table until we,
the 3.25.
yeah. So let's move on to number 6, discussion of next steps. So we've already agreed we'll come back to this storage facilities again for another day. What we want to do though now is we're going to talk about and actually the public comment periods. You can raise anything you want within those 2 minutes, but we're going to, it sounds like the primary piece of this public comment period will be to talk about the permitting, then the new rules around suspension, revocation, and then the appeal process. But again, anything you want to use for your 2 minutes is fine. After we go through the public comment period, we will then move on to the TTAB vote on recommendations. We'll listen to the public comments and decide how we kind of want to address the TTAB vote after that. So let me move it on to the public comment period.
And how many minutes are we doing per public commenter?
Yeah, I just read
We can
2
do
minutes
2,
here.
3,
so.
or 5.
Well, we could do 5. Well, I'm all right with 5. Is unless you have a whole army of people coming in that we don't know about. Is it just the 3 of you?
It's just us. We didn't set you up.
Okay.
Section 8, 14.3 still, section 8. That needs to be taken out. That is going to be burdensome. He's always coming. Whether they're here tonight or not. That's a full-time job. But property management, the assistant property management takeover, David's been takeover towing. We've got to notify the county of all these changes. That's a full-time job. I'd have to hire someone to do this, make sure the county's up to date. Even though the county gives 30 days to notify them, but by the time we're notified that they got rid of the maintenance guy and the maintenance guy's no longer in charge of the towing, we could be in violation. There goes your appeals. Now you're in trouble. Now you guys do an appeal. Fairfax doesn't require, no other county requires, city requires it. Arlington County doesn't require it. Like now, I'm not no lawyer, but I don't know if it's a period in a third-party contract, period in a contract, not whether it's a legality, the tort law. I don't know too much, but I know that this is very burden to everything as far as that. I think that over here in section 8 of the revocation, I think we're just a lot for within that. I know the front of the sentence says towing, immobilization, approval, towing, and storage vehicles for private property. But I tow for a lot of motor clubs. They live in Arlington. They ask me to store their car at my lot. I'm in the appeal process because somebody made a complaint. Super made a complaint, so I'm going to go through the appeal process. But is this going to shut my towing company down from towing a motor club car there that they asked me to bring to my storage location that I charge them for storage? I mean, you're shaking your head no, but I got to make sure you know the whole thing. I'm charging them for storage to bring it here so I can deliver it the next day to the body shop and the mechanic shop. If I'm in violation of the county code for doing that, there's a lot of things that need to be clarified. And I mean, this is a lot of information to take in at one time. But yeah, section 8 is that's a lot of work. That's a lot of private information that's being given out. These property managers, stuff like that, they have us tow cars. We tow cars. So that's very easy. Nobody employees have their car towed, but they parked illegally and they got towed. You know, they don't want, you know, the majority of property managers are females. They don't want their names given out. And next thing you know, they're sitting there in their car waiting for them to go off to work. You had my car towed. I mean, this is a real touchy thing. And, you know, I'm not big in Arlington County as far as private account towing, but, you know, you never know. I might be tomorrow. But going by this, what happens if I'm in the appeal process? And then my contract finds out that I'm in the appeal process because the county says I did something wrong, because the consumer that we're protecting here made falsified statements. There's nothing happening to that consumer that made these falsified statements, but what's happening to the towing company is he's providing the pictures, the contract, this, that, the blood sample, he's supplying everything to the county board manager, police department, the designee, whoever it may be, applying all that. But that being said, now one of my competitors, here all you know, everybody likes him, he comes in and takes my contract for me because he knows I've been put on hold. What about if I found not guilty? He just got my contract. I didn't do anything wrong. So then, this is the fine line of putting people out of business. It's what it is, depending on how far people want to take it. Yeah, we've been in Arlington County a long time. I've done business in Arlington County. I was a resident in Arlington County for a long time, you know. And so it's just, this is a lot of paperwork here that needs to really be going through, especially sexually. Right.
So, not to say that the traditions. Yeah. Probably out of county, but the in-county permit passed legislation to pass special down. 2012, I set out to make it able so that vehicles can pass from one county to another. Because Fairfax at the time had it in their ordinance that you could not do that. Down in Richmond, I got Senator Morrison and the delegate from us to sponsor a bill that essentially allows us to do that. Fairfax's concern, and Arlington's concern actually back then, that now a county tower, not having a business license in the county, we have absolutely no teeth or ability to control that out of county tower to do what is required by that ordinance. So, out of county tower permit reform, and that legislation, a lot of lobbying, passed the House 97-3, passed the Senate 39-1. Anyway, that allowed us to bring cars that have to wait from Fairfax to Arlington, because where my lot is located, Fifth Road, is very close to the other crossroads and Southern Corners. There was no storage facility in that area to tow with the store cars. So cars from there would either go down to Vanderbilt Street or out to Merrifield. And people there like the idea of being able to come right across the border to me. So with that, moving forward, this past year, Governor Port did a bill. She had absolutely no idea what it did. She just said it should have a permit for the county tour. Out of county tour hasn't been a county tour. She had it. She didn't know what it did. She had no clue. She couldn't tell the towing street. She couldn't tell the turns. She couldn't tell her colleagues across the outdoor. That permit, the way that I read this, you know, for me, to me, it's dangerous because it's actually said it's on me. I'm the only person with a storage facility in the county. Everybody knows that. I've been in business for 19 years. We're based here in this county. Came back after college, raised my family, bought that land at Fifth Road, made an investment in the county. I pay insurance, taxes. I believe because the park is still outside the county, 2.25 miles, which I agree with. There's a lot of information that's being said around here that's just not correct. The reason why it's a Fairfax County code is because they put that in there 6 years ago. Couldn't do that. They just passed the law just with effect July 1st. So the permit system they're talking about wasn't going to be happening. Now they can do better now because it just passed in July. So that's why they came with the registration system. Register all your towers in Fairfax out. And Ones that go out of county, they have an out of county permit, just like Arlington County does. However, the out of county permit that was put in place 12 years ago has had no oversight whatsoever by any HAC inspector, current or before, none. It's a problem for me. It cost me countless dollars in operating revenue. Ability to run my company correctly. Fights with attorney general, 150 grand, 2 years of fighting for a $750 fine. It's ridiculous. Your current ordinance is working. Current ordinance, we had what, FOIA requests, 90,000 tows in 5 years, 221 complaints, 27 found to be valid. It's 0.02. How good do you want us to be? What more can we do? Make it harder? Look at the ordinance as a full and full. What part of it is good for the tow? Any part? Not even the fee section. I still get less amount, and I'm the most expensive place to operate in the entire state. And I'm honest. I urge you to tell the county board to do away with the permit. You don't need it. Have a business license. What that come after it, there's a mechanism in place. We go to court. As far as complaints go, Caitlin Thomas has actually reached out to me for a couple times against complaints. I've answered her. I've actually confronted someone and gave somebody the car back. I've always wanted that ability. She's done it. This is unnecessary. Stop. You know, I was made wide down she was passionate about it, to testify. One county attorney in the lobbies for one county was able to mislead. I won't say live, because I don't think they knew. She was in elementary school for Christ's sakes when I put this through. They don't know what it was back when I put this in place in 2012. Like that. They all got bored with something that's just ridiculous. I wasn't allowed to testify for the Senate Transportation Committee. So it was passed without the correct information. Nobody knew what it was. But back in 2012, I got it passed. It passed. Always unanimously.
Thanks, John. I also think there might, we can open it up to people who've called in. Is there anybody who wants to share a comment? Owen? Okay. I can't read all the names here. I'm looking at them from.
Just for everyone who is attending virtually, we are doing public comment. If anyone on the call would like to provide input, now is your time, please.
I'm looking at the screen here. No one. Okay. We lost our screen here, so.
I just wanted to reach out, John Musso, Matt Chiste, I believe, and there's another MR. If you all want to come off mute and say anything, please do so. Or you can raise your hand as well.
Sorry, Caitlin. No, we don't have any comment at this time.
Yeah.
Mr. Chair. So I'll be way shorter than 5 minutes. Just an update on process, just so that everybody knows. The plan that I have, at least, is to try to do a September county board meeting. That's an initial discussion of this. And then either in October or November, after that initial hearing, we would take it up again and pass it final either October or November. I checked with the county attorney, and the process would enable the TTAB to meet between the September meeting and whenever we take it up a final time. So you're going to have 3 more opportunities to engage. I've been listening. I'm here not because I told you about my 7-month-old last time. I wanted to tell you about the process. Al, there are 2 parts where or their designee. There's the county board appeal process, and then there's the county manager process. And it's open-ended enough currently that it could be anybody. It could on both sides. If the county manager was trying to get his wife out of a tow, by falsifying statements, that would be an issue that I would consider serious in his performance. And I don't think he would do that. But if he did, that would be a very serious issue, I think, for all board members. I understand the concern because it happens in localities across the country. So that's on that designee side. On the other designee side, the county board, when we work on this in September and either October or November, your comments will be in my mind. And then I heard a bunch of times about Section 8. I certainly will want to take a look at that. It's helpful to be here. Those are the specifics. I want to understand a little bit more about Fairfax's process. And if it is word for word in Fairfax's ordinance, and there's some reason why Fairfax's ordinance is not the law, is not good law, or somehow there's questions about Fairfax's ordinance, please come find me. But and I'm happy to have that conversation. But also in September, you should know a couple of questions. Legally, we have to put it on the website and we send it out in an email. And that doesn't mean humans don't check every email they get. For goodness sakes, it'd be terrible if we did. But I'm telling you now that either at the September Saturday meeting, which we can get the date for, or at the September Tuesday meeting, it's likely we'll take this up in some form. It won't be the final time, but I want you to know so that you can get me specific edits that you might have on Section 8 or his designee or whatever is concerned. So I'm trying to just lay out the process. Thank you, Mr. Chair. I know that we talked briefly 10 days ago about the process, but I thought it would be okay if I just shared the process. And I hope that's some indication that I am listening to each of the things that you guys have mentioned. Thank you.
Thank you.
We posted it, I believe, 2.5 weeks ago. It's on the TTAB page. It is on the meeting calendar. There was a Gov delivery blast to about 900 subscribers, and it was physically posted in the lobby of this building at the same time it was posted online.
Well, we are at a point where we are scheduled to vote on the recommendation. I think what our county board member, Matt, just shared with us is that there is a very methodical process that's going to unfold over the next few months. The role of the TTAB is to make a recommendation to the county board. And at that point, the county board is required, number one, by law to provide an invitation to respond to this new rule, which, as we talked about a few times during the meeting tonight, is when you all can get with your legal advisors, your legal counsel, to look closely into comment specifically on parts of this proposed ordinance that are problematic, both legally and administratively. And if government works the way it's supposed to work, you bring those comments boldly to the invitation process. And if county leaders are responsive to their constituents, they're going to hear these as legitimate comments. So, you know, that again, I don't want to minimize in any way that invitation to respond process, because it's where you officially in writing can indicate those sections of the ordinance that are problematic. Again, our job tonight here as a advisory board is to take what's been proposed as the ordinance, specifically section 14.3-12 permits and 14.3-13 appeals. That's the sections we're looking at tonight, and saying, as a advisory board, do we recommend that the county board take these up as proposed as ordinances to be implemented in the county at a future date? So what I'm going to do at this point is ask for a motion to recommend that these two sections, 14.3-12 permitting and 14.3-13 appeal, be recommended to the county board.
Second.
It's been seconded. So we're now going to vote as to whether we bring these to the county board. All in favor, say aye.
Aye.
Aye. All opposed? Okay. So the motion passes. These two sections will be brought to the county board. That concludes our meeting tonight. Thank you all for comments. Thank you all for just what you all do. It is appreciated.
Thank you, everybody. Appreciate it.
And this meeting, motion to close the meeting.
Second.
We're closed.
We'll do my homework for the next one. You can, so we'll have
Well,
more.
It's a lot, you
It
know.
is.